assignment presentation for the case White House versus Carlton Hotel. I am start with the introduction. Charles Whitehouse is governing director of the Carlton Hotel. Charles, Charles owned a class shares which have full voting rights, and his wife Mrs. Whitehouse had been issued B class shares which had partial voting rights. The daughters and the sons both, who had C class shares and no voting rights. The couple divorced and the daughter aligned themselves with the mother, the son, and with the father. The dad has concerned that on his death, the mother and daughter would get control of the company, so he issued B class shares to his sons. He then had a falling out with his shares and then resolved that no B class shares had been given to his shares and directed that the shares registered be amended and the sons sued. Thank you.
Hi, it's me Kushal, and I'm going to tell about the duties and responsibilities breached and why the duties were breached. After a detailed review of the Corporation Act, it is clear that Mr. Whitehouse breached to act in good faith at all times and to ensure that his actions were against the best interests of the corporation and its shareholders. Mr. Whitehouse seemed not to be keen to act in good faith and that he was not honest in his dealings, especially with the distribution of the shares. It was clear that he aimed to maintain the lifelong unrestricted voting rights that he had been allotted to him with the Type A shares that he had. Clearly, Mr. Whitehouse had not acted honestly as per the responsibilities that he had to take to the other shareholders of the company. His actions indicated that he had failed to maintain the duty of care and the responsibility to act in good faith that had been bestowed on him as a director of the company.
Hi, my name is Meenakshi Kaur and I'm talking about the court decision in the view of the Corporation Act. In this case, the High Court deemed the allotment of the shares invalid. The ruling found fault with the allocation of share because it found out that it was not done in the good faith but rather with ulterior motives. On the other hand, the court observed that the eventuality of the director's contestations was inmed- inadmissible as the third party affected by the circumstances is not aware of the breach of the duty and thus enjoy protection from the indoor management rule. The third party, Mr. Whitehausen, in this case, become the bona fide shareholder with Class B status and without the knowledge of the motives of the director, and therefore the shareholding stands. The judge perceived that the company director pursued personal interest at the expense of the company's interest, and this went against the spirit of good faith.
Hi, my name is Lydia, and I will be talking about the relevance of the decision to the development of Australian corporation law. This case revolves around the director's duty to act in good faith and in the best interest of the company and its shareholders. When it comes to the development of the Australian corporations law, after this case, the courts will now always consider if the director gave the proper consideration to the company's interest. According to Mr. Whitehouse himself, he believed to be acting in the best interests of the company. As a result, the court appeared to accept some cases and excuse the motivation to influence the control of the company. It clearly shows that the law in this area is still uncertain, sometimes despite the clear evidence of the reasoning behind directors' actions. The company's directors had the powers to offer shares provided the reasons for doing so were to the benefit of the company and in line with the firm's constitution. In other scenarios, the voting powers can be interposed and it could occur to the present shareholders. It can also be that new voting powers can be created. Mr. Whitehouse's actions were therefore against the fiduciary responsibility accorded to him to uphold the proper purpose of every decision made.